process. We will remain vigilant in our efforts to hold police accountable and will continue to work with community partners to ensure that police officers do not continue to break laws with impunity. Those days are over.
Good morning. My name is April Green. I am the aunt of Kiete O'Neill, who was murdered by San Francisco police officer Samuel on December 1st of 2017. I watch his mother, who is my sister, suffer in pain daily from the loss of her son. This is the first time in the history of San Francisco that we have a district attorney who truly speaks for families who are at an economic and socially disadvantaged. This is the first time that officers who abuse the law are held to equal accountability for their actions. This is the first time that crime has come down because Chesa Boudin has taken on the role of watchguard over the San Francisco Police Department. Families are now able to sleep and rest more peacefully at night, knowing their children can walk the streets more safely without fear of them being murdered by an officer. We need to hold police accountable for those who abuse their position of power, of authority. We cannot trust the police to monitor themselves. We need Chesa to stay in office and watch over our people. Thank you.
I want to thank our courageous speakers and again acknowledge that the Monterosa sisters had hoped to be here and that one of the critical issues in the killing of their brother was precisely the fact that there was no independent agency investigating his death. Was precisely the fact that, in fact, in the end, no one investigated his death. The police refused to do it. The district attorney refused to do it. No one stepped in to even analyze the facts and consider whether or not a crime had been committed. That is devastating to families who lose a loved one, particularly at the hands of police. We know that this topic of police violence is a painful one, and I want to thank April for your courage being here today. The MOU between our office and SFPD was designed to ensure that when police use force or someone dies in their custody, there is a clear, transparent protocol in place so that everybody knows exactly what happens. This protocol ensures that SFPD immediately notifies our office so that we can independently investigate. Under the MOU, our independent investigations team, many of whom are standing here with me today, respond 24/7 to the scene of a covered incident. They investigate the use of force or the death. They collect evidence. They speak to witnesses, and they conduct their own thorough and speedy independent investigation into what happened. If it is determined that a police officer's use of force was lawful, and that is what happens in the vast majority of these investigations, let's be very clear, then we announce as quickly as we can conclude the investigation, and it has happened more quickly in the last 2 years under my administration than ever before. We announce that we cannot prove a crime occurred, and the officers can move on with their careers without having an investigation hanging over their head. If it is determined, however, that we can prove a crime did occur and was committed by a police officer, we will hold that officer accountable, just like anyone else who commits a crime in San Francisco. This is what equal justice under the law looks like. So why does this MOU matter? First of all, because accountability matters. And we cannot expect, and history has shown us time and time and time again, that officers cannot effectively investigate themselves or their fellow officers. And we know that police violence does not happen in a vacuum. Police violence has disproportionately hurt communities of color, and withdrawing from this MOU will disproportionately hurt those very same communities. The impact runs deep, not just for those that are themselves harmed, injured, or killed, but also for their families, their friends, for their neighbors, and for all of us in San Francisco who are committed to the rule of law and to equal enforcement of the law. We need our communities, all of our communities, to trust the police and to cooperate with law enforcement when crimes occur. And we know that it is much, much harder when there is no accountability for police violence. Now, I want to be very clear. My office and my team in the Independent Investigation Bureau intend to continue to investigate and, when supported by the evidence, prosecute police who break the law. But there can be no doubt that ending this agreement would impact our ability to do so effectively. In other words, without the MOU, there is nothing to guarantee that we'll be notified when police officers discharge their firearm or when someone dies in their custody. There's nothing to guarantee that the scene of the crime will be preserved for us to review and speak with witnesses and gather evidence. There's nothing to even guarantee that we'll be given access to crime scenes so that we can conduct an investigation when we arrive. That was the whole reason for the signing of the MOU to begin with, back in 2019. It was to provide for our independent investigation of police officers. Walking away from the MOU means abandoning that commitment to justice. We cannot lose sight of what police accountability means here in San Francisco and across the country. Why does it matter? As we stand here, we're less than 2 years out from the murder of George Floyd. Millions of us across the country and right here in San Francisco reckoned with the righteous rage we felt as a result of that murder. We were outraged by the sense of impunity with which Officer Derek Chauvin sat and kneeled on Mr. Floyd's neck for nearly 9 minutes. Police accountability matters. Our office will continue to fight for communities impacted by police violence. We will continue to ensure accountability for all who break the law in San Francisco, and we will continue to fight for equal justice in San Francisco. Thank you.
So DA, how can you ensure that accountability matters and the IIB is going to be able to handle these investigations and give justice to these families when your own people in the IIB are on the witness stand in court saying that they were told to commit prosecutorial misconduct, they were told to remove exculpatory evidence from an arrest warrant, and that they felt pressured into doing so or they'd lose their job? I mean, that's really what's at issue here, and part of the reason why the police department pulled out of this MOU.
Evan, thanks for the question. As you know, there's a gag order in place in the case that's currently in trial. What I can tell you is that, and I think you're aware of this, Evan, this is the first trial in modern San Francisco history, first time ever, when a police officer on duty accused of unlawful force has actually been brought to a San Francisco jury. It's the first time ever. It is no coincidence that it is in the middle of that trial that the department chooses to walk away from this MOU that has been working based on allegations that predate my administration. If, in fact, there were violations of this MOU at any point in time, the appropriate remedy would be to sit down and talk about how we fix those kinds of violations and how we prevent them from occurring in the future. I've had that conversation with Chief Scott many times when SFPD has violated the terms of the MOU. It is not uncommon. My office has MOUs with more than 70 different city agencies, nonprofits, and corporations that we do victim services work with, that we share resources and investigations with. And violations of MOUs happen all the time. What doesn't happen is politicizing those violations or allowing the police union to dictate who investigates police officers accused of excessive force.
This was one of your own people in your own office saying this, so you can't blame the POA or the police department for everything. These are your people up there saying that.
When you say my people,
One of your investigators inside your office, inside this IIB that you're talking about being so important about police accountability, is saying
No.
that
This
this investigation is not being conducted on the level.
Right. As
So what do you say to, if the case is already getting messy, the very first one, as you said, how can the public of San Francisco that was completely behind the IIB being the lead investigation agency and all these things, how can we as taxpayers in San Francisco have faith that your office is going to be able to handle these and potentially bring these people to justice if that's necessary?
Well, you can listen to what the judge said, and as you know, I can't comment directly on this case, unfortunately. But the transcripts have been posted all over the internet, and I would encourage you to read them. I know, Evan, you spent a lot of time at the Hall of Justice.
I was in court watching this play out.
And over the years, one of the things that I know you have learned, as have others here today, is that it is a common tactic of defense lawyers to try and distract juries from bad facts. That's a common tactic. And I would encourage you to read what the judge said, to read what the evidence shows in this case, and to look carefully at the chronology. Because I can assure you that when my office, when my team makes mistakes, we own them. And I can tell you that we did not make mistakes under my leadership in this case. And that's what the evidence will show.
Mr. Boudin, I know you talked about the importance of accountability within the police department, so I wanted to ask about accountability in your office.
Sure.
Specifically as defendant James Durgan. This is someone who police have arrested more than 60 times. You have a victim in this case who fears for her life and thinks your office isn't doing enough.
You know, I think we're going to focus on the topic that we're here to speak about today. So if anybody has any other questions about what we've been asked.
And let me, because I want to make sure, we are here to talk about a very specific issue. So let me try to answer your question, but I want to bring us back to the topic at hand. The issue is when someone is a victim of crime, whether the crime or the violence, if not yet determined to be a crime, whether it's caused by a law enforcement officer or whether it's caused by someone who doesn't wear a uniform or a badge or carry a gun lawfully. Regardless, when someone is harmed, it is a top priority for me and for my office to find ways to support and protect and heal those who've been harmed. There is, if I could finish,
I was just going to say,
you asked, I just would like to finish. Thanks. There is no doubt that in some cases, regardless of who the suspect is, regardless of who the person who caused the harm or used the violence is, that the tools at our disposal as prosecutors, for judges, for police, for sheriffs, in many instances those tools are inadequate to fully address the societal harm, to help people heal, or to prevent future crime. We know that. We see that 2/3 of people coming out of state prison will be rearrested for new crimes. We have not, as a society, we have not come up with a panacea to solve problems of crime and public safety, particularly when driven by mental health. We're doing our best, and I think the focus of today's conversation and the other questions that I'd like to answer, if there are any, has to do with, is it related to the issue? Sure.
Mr. District Attorney, I know you mentioned the judge's comments. She was repeatedly quite clear in that she felt like it was not her role to decide whether there was misconduct or there was not misconduct. She was not going to opine on that issue. She was determined, she said, to figure out if the gentleman on trial, the officer, was actually having a fair trial. She did. The judge herself, who you, I know, were quoting earlier, the judge herself said that the MOU was not followed. This was an MOU that you're saying is so important, yet your own investigator said she was pressured to withhold information from the police department.
So I want to be really clear. I didn't quote from the judge. I encouraged all of you who are interested in covering what happened at that hearing to read the transcript. I wish that I could talk in more detail about it. What I can tell you is that we have done absolutely everything by the book in this case. There is not one iota of evidence of misconduct under my administration. To the extent there were problems with communication, they predated my tenure. I saw a question over here.
So you mentioned earlier that if there has ever been any kind of a violation on the part of the police department, it's a conversation that you've had with them about that. In this case, I'm curious, we're at a news conference early in the morning, but have you actually reached out to the police department to talk about this incident and try to iron it out privately?
The first that I heard of the police walking away from this MOU was yesterday late afternoon, shortly before all of you heard about it in a press release. The MOU, as you're probably aware, provides for an opportunity to meet and confer within 5 days, and I fully expect to sit down with Chief Scott and to walk through the facts of what happened when, and I am 100% confident that if there were problems, they predated my administration. And there is
You guys have
no,
already been in communication to set that up, that meeting?
we have not talked today, no. We will.
But, Mr. Boudin, you charged the officer here.
Yeah.
So saying that the problems predated your administration, you inherit those problems when you make a
Sure.
charging decision. And then
Sure.
the other allegation here is that this DIA investigator was pressured into signing these warrants. And I get that there's some contention over whether or not that was exculpatory evidence or not, but their accusation is that you were going around minimizing it as well in the press, the sort of precipitating factor that led up to this police use of force case. Do you regret doing that? Do you think that you should have handled that differently? And do you think that accusation is fair, that Mr. Spears' actions were minimized in order to bolster your case against the officer?
Evan, I often regret taking phone calls from you. No, I'm teasing. I'm teasing. I love hearing from you, but sure. Do we sometimes wish that media coverage of a particular issue didn't turn out the way it did? Of course. I don't control what any of you write. What I can tell you is that your question is conflating two separate issues. And I, as you know, cannot talk about the details of this case. I wish I could. And you know me and you know that I wish I could. But what I can say from a more abstract level is any case that makes it to a jury in San Francisco has survived, any felony case, has survived a preliminary hearing. A preliminary hearing is a probable cause hearing. It's a hearing where, regardless of what was or was not said in the arrest warrant, regardless of whether or not the arresting officers did or did not do everything by the book, a preliminary hearing is an opportunity for an independent magistrate with lawyers on both sides of the case to decide whether or not probable cause to exist. And after that hearing, after a magistrate determines, in every case in San Francisco's Hall of Justice, in every felony case, after a magistrate determines that there's probable cause, regardless of what's in the warrant or what the police report says, the defense counsel has an opportunity to argue to a different judge that that magistrate got it wrong. It's what we call a motion to dismiss, a 995 motion. In every case that makes it to a jury, where there are felony charges, there have been two separate and subsequent to the arrest warrant determinations that there is probable cause for those specific charges to be presented to a jury. Every case.
Mr. District Attorney?
No, I'm sorry, but God, this.
Thank you. A lot of this has to do with trust, and regardless of whether this predated your time or not, I'm just curious. I mean, we have the opportunity to hear from you now about the fact that someone in your own office did testify that they were pressured to withhold evidence. So that should concern you. What I want to hear from you is what you are going to do about it now, regardless of whether it predated your time.
Sure. I want to be clear that I can't comment on any potential pending HR issues, and I need to know what happened, because if someone in my office is pressured to do something that's improper, that's unacceptable. And whoever pressured them has to be held accountable.
So are you actively working to figure out what exactly happened in this particular case?
Absolutely. And I am not aware of one iota of evidence, not an email, not a documented conversation, nothing that occurred during my tenure that could possibly suggest that it is ever acceptable, under any circumstances, to be less than 100% truthful and candid in affidavits filed under penalty of perjury.
And I know you can't talk about the specific case
I
here.
know,
Talk about the larger-
Michael?
He asked like four
Michael?
questions here. Can you just talk about the larger?
I know, but we're going to let some new voices in as well. Michael?
DA, so to what extent do you think that the decision by the chief yesterday was motivated by pressures coming from City Hall or an attempt to influence the recall election against you?
I'm not going to speculate about what his intention is. I read in Evans' reporting, others may have reported it, that there was talk of a recall, of a vote of no confidence against the chief. You know, I don't know. I'm certain that the police union has been resisting this MOU since well before I was elected. As you know, they spent, I think you broke this story back in 2019, Michael, they spent over $654,000 in just a few weeks trying to ensure that I wouldn't be elected. And one of the main reasons is the issue we're talking about today. So regardless of what the chief's intentions are, voters in San Francisco can be sure of one thing. Police accountability is on the ballot in June.
I'm kind of curious where we go from here. I mean, there's a lot of concern about the backstory, but in all practicality, how do your investigators now show up at a scene and try to conduct an investigation? I kind of want to know, what are you guys going to try to do to salvage this if it's possible? And then how are you going to operate thereafter?
Just really quick before you, this is going to be the last question, and then we have Spanish language, and so thank you all for coming. And
Thanks, Robin.
Yeah.
It's a great question. The first step is for me to sit down with the chief and to go over, in a context that we can't do here because of the gag order, what his view on what happened is, what violations he believes occurred, what transgressions were or were not, and really walk through the timeline. And I'm confident that he will see that this team, under my leadership, has done things by the book, and that there's been no prejudice to any investigation, there's been no prejudice to any case, and that to the extent there are miscommunications, they are a normal part of the back and forth of any MOU, and they're exactly of the same nature of the kinds of miscommunications and violations of the MOU that happen by the police. If the police chief is unwilling for any reason, perhaps some of the reasons that Michael was asking about, I don't know, if he's unwilling or unable politically to continue to move forward in good faith with this MOU. And let's be clear, this is an MOU that needs amendments. We amended it just this past year. It needs amendments on an ongoing basis. It's a living document. Every investigation that these folks get called out to, they learn what works, what doesn't work. We get feedback from the police. We give them feedback. And every year when we renew it, we make changes to try and recognize the reality on the ground. My hope is we'll continue to do that in good faith. If the police department is unwilling or unable to continue to notify us and give us access to scenes when they use force or have an in-custody death, then we'll go back to doing what we did at the beginning of 2019, before the MOU was signed. We'll go back to continuing to show up as quickly as we find out. We may be hearing from some of your Twitter feeds. We'll go back to talking to witnesses outside police lines if they won't let us in, and doing our best to ensure that everybody in San Francisco knows there's an independent watchdog and that police are not being asked to investigate themselves.
Do you think the agreement's salvageable?
Absolutely.
Mr. Boudin, we don't get a chance to hear from you often. If you could just respond to your
I do want to make sure that we give equal access to non-English speaking journalists. We've had a lot of questions. I'm sorry we don't have more time to take other questions, but I want to make sure we have time for those that speak Spanish.
And you all can always email anything else to us, and we can respond to you if
You guys
we
don't
can.
respond, that's the problem.
You have a deadline for 3 p.m. We're going to get back to you in just a little bit.
We're gonna do it in your office.
Okay.
Do you want to come with us? Great.
Thanks, everyone.
Thank you all very much.
I'm the honor of Kiete O'Neill, who was murdered by O'Neill is O-N-E-I-L.
Director of the ACLU Criminal Justice Program.
Thank you, thank you.
Yeah.